Okay, hello everyone and welcome to today's webinar. I'm Rose, Marketing Manager at InfoTrack. Today we are joined by Brian Rogers from Riliance and he'll be taking you through the Data Protection Act. Please feel free to ask any questions during the session and we will respond to these at the end. And if you're having any issues with sound or visuals, please do type them in the box and we can respond to that. So over to you, Brian.
Thank you very much, Rose, and a very good afternoon to you all. As is my norm with webinars and seminars, I do not want to get involved in lots and lots of regulation and red tape and all those things. So you'll be pleased to hear that I'm not going to be throwing article this at you and principle that at you. I want to try and keep this as common sense as possible and also as simple as possible. So hopefully that will get us off to a good start. So moving straight on. Yes, this is me, as Rose has just introduced me there. I do a lot of work with various firms, do a lot of sessions with people, and as I say, I very much believe in keeping things simple and also providing case studies and examples. So a lot of what I'm going to discuss today is so that you can actually put this into a day-to-day operational environment. My rule of thumb, or certainly one of my rules of thumb, is do with others' data as you would wish done with your own. Now, obviously, if you're happy to be throwing your data around like confetti, well, I'd certainly be thinking twice about that. But I suspect you all want to make sure that your data is being looked after and is secure and being updated as appropriate. So if that's what you're going to expect, then obviously you need to make sure that that's what you provide to other people as well. I think the other thing I'd like to sort of start off with is the fact that you are individuals, you are data subjects in your own right. So don't just have your business hats on when I'm going through this. You are data subjects and you have all the same rights that we're going to be going through. And so, perhaps you will want to use some of these rights and some of the things I'm going to be talking about today to actually be able to exercise your own rights to get things done with your data or get the right to be forgotten, whatever it might be. So, this is for you and it is also for your businesses as well. I want to do a bit of myth busting. Now, this is certainly something which the Information Commissioner has been very, very hard on. She's really wanted to bust a lot of the myths that have been floating around out there by people who have been trying to sort of jump onto the GDPR bandwagon. So here we are, the ICO not looking to make examples. She has clearly said in a lot of her press releases and at conferences which I attend that she is not looking to make examples of people just to get a point made. She will attack people, she will go for firms if she sees that they are doing the wrong thing. But that will be based on intelligence that she receives. So, for example, your clients not happy with something, you're not looking after their data, you're allowing it to go into normal waste bins rather than shredding, and it's then found in a dump afterwards. These are the sorts of things that she will be looking at. So please don't think that she is going to be making examples. You won't be fined £17 million or 4% of global turnover. So again, that's something you shouldn't be worrying about. Now, I'm going to give you a couple of examples in a moment of firms that have actually been fined under the old Data Protection Act. And you'll see from that the sorts of fines that have gone out there and how that's going to apply to the new GDPR regime. There's other sanctions that will be levied before fines. So again, yes, we've had all these rumours floating around about these £17 million fines or 4% of global turnover, people getting really worried about those. But actually, if there are issues, the likelihood is the ICO is going to contact you and put a notice on you to say, come on, you've made mistakes here, you need to sort yourselves out, get yourself sorted. It will only be where quite clearly large organisations or other organisations who really don't give a damn about people's data, it's them that they will be going after. So as she put it in one of her statements the other day, this is not to try and stop your run-of-the-mill law firm, your butchers or whatever it might be from operating. It's business as usual for them, but that doesn't mean that you can ignore what we're now having to do in terms of data protection. Just something which you might be interested in, I actually did a poll of a number of law firms some time ago a couple of months ago, and something like 36%, I think it was, said that they actually weren't compliant with the existing data protection legislation, let alone the new legislation. So quite clearly there are some people who are even picking up the pieces now to get running, rather than sort of being a long way down the track and then having to pick up the new pieces to go with it. You need to be proportionate in how you deal with GDPR. This is not about putting lots and lots of cost on firms and such like. So this is not about me coming into your firm or any other firm and saying, right, okay, well, you need to replace all your filing cabinets because none of them have got keys, or replacing all your open shelving because you need to buy filing cabinets. If it is not proportionate to the risk that exists, it might be that you just need to turn binders round so that clients in your office can't see them, or to put a curtain across open shelving, whatever it might be, to minimize the risk of data not being treated properly. But it certainly isn't about putting lots and lots of cost on businesses. And that final one, the ICO is not waiting for you to trip up. Lots of people do tend to think that regulators are waiting for you to trip up. The ICO has very much said that this is a carrot and stick exercise. It's going to be an ongoing exercise. And certainly if you have a look at the ICO's website, there are a lot of very, very good pieces of advice, guidance, checklists, all those sorts of things. So I don't think anybody needs to be worried about GDPR. They just need to be positive. They need to be realistic with all of this. But as I've said before, you need to keep it simple. I've just talked about obviously getting rid of a lot of the myths. So I'm not putting this slide up to try and frighten you. What I'm trying to do is just show you here that the ICO is not a silent organization. They are out there, they are looking after people's data, and they will find where it is appropriate. But you can quite clearly see here that, bearing in mind the top level of fines under the old Data Protection Act was £500,000, even where there were big issues, they weren't using that full £500,000 fining power. So we've got 250,000 for Yahoo. Obviously, there were issues there. We've got the Bible Society. So again, the charities, sometimes they need to make sure that they're looking after data. I've been working with a number of charities, and one of the biggest risks to them is all the volunteers, because they tend to think, well, I only work a couple of hours a week and therefore, you know, I don't come under all of this stuff. Well, yes, they do. And you have to make sure that they're playing the game as everybody else is doing it, and reading the policies and having the training and everything else. So, you know, charities can be hit just as much as any other business. And of course, we've then got the one at the bottom here, which is the Crown Prosecution Service. They were fined 325,000. So, you know, lots of big organizations making mistakes, but there are smaller organizations who are making mistakes. Certainly there was a law firm some time ago who was fined because they allowed some of their files to get out of the office, and they were found on the canal path behind the solicitor's office. And the first thing they knew about it was when the local press phoned them up and said, what are you doing allowing people's data to be found on a canal towpath? So you do need to be very, very careful. Make sure that you are keeping track of your data. This is why you have to have an information asset register, and therefore you can track where your data is coming from, where it's going to, what you're doing with it while you've got it. Otherwise, you could end up with fines and as I say, notices telling you to improve what you're actually doing. Now, some people will say that if, let's say, for example, the CPS at the bottom there did get a £500,000 fine under the old regime, that they would therefore get a £17 million fine under the new regime because they got the maximum. That isn't the case. You cannot correlate one to the other. What the ICO has said is that if they get a fine of £325,000 now, that is what they'll probably get. Sorry, I say now, under the old regime. That is what they'll get under the new regime as well. So certainly a lot of the fear factors have been put out there based on the fact that if you get a maximum under the old regime, you're going to get a maximum under the new. That isn't the case. So please don't focus on the fines. You know, you should be focusing on what is good for your business, what is good for your clients, and the data subjects that you deal with. Now, in terms of data protection, the history, I'm not going to go into great detail of this, but suffice to say there's obviously been a lot of things hanging around, and just picking up on the UK stuff there, we've got the Data Protection Act 1998 and the Human Rights Act 1998. Now, who would have thought back in 1998 we would be doing what we're now doing with technology? So, who would have imagined that we'd be doing the things with laptops, with phones and all those sorts of things? Certainly the legislation hasn't kept up with the technology, and therefore we need to make sure that it does, and GDPR and the new Data Protection Bill 2018 is where it needs to be to take account of all the improving and enhanced technology that is there. It wouldn't surprise me, and this is only my personal view, but it wouldn't surprise me if we have to have a revisit of the GDPR and the Data Protection Act in a few years' time, because obviously we've got artificial intelligence coming around the corner, we've got driverless cars, we've got all sorts of things like that coming around the corner. But of course, with all this new technology, it allows us to do things on the move, which is fantastic. But one of the biggest problems that I find is that people are not identifying the risk of working in public areas like trains, and therefore they're not mitigating that risk. And certainly when I'm going up and down the country on trains, I'm seeing people working on the trains, and they are allowing people to see their screens. You get lawyers who will open their files, they'll put them on the desk, they'll be talking on open phones about their clients' matters and things like that. That is all bad practice. It is all breaches of the Data Protection Act. Now, does that mean that you can't work on trains or in public places? No, it doesn't. What it does mean is that you need to identify the risk that people's data may be seen or heard or whatever it might be, and therefore you take action to avoid that risk from taking place. So, for example, where you can see in this particular picture, somebody has got a laptop. Well, what you would want to do is put on a screen filter so that people can't see from the side what you're actually doing. The only person who can see it is the person sitting in front of it. Again, what you don't want to be doing is having confidential phone calls when you're in a public area. So on a train, I mean, I've had so many experiences where I've actually learned so many things about clients and other businesses because they've been discussing confidential information. It's unbelievable. But the train, the train is not your office. And just because other people do these things doesn't mean that you should. You have a duty to protect information, and that's exactly what you should be doing. The other thing, of course, is when you are going into other public places, like a lot of people will go into coffee shops and they'll sort of have a coffee while they're waiting for meetings and things like that. Again, what you should be looking at is not where the coffee is, but where are you going to sit once you've actually got that coffee. You should be making sure, if you can, that nobody can actually see over your shoulder, that you haven't got CCTV within the premises actually looking over your shoulder onto your screen and perhaps recording that. More importantly, what you shouldn't be doing is using the insecure Wi-Fi within these places, because there's criminals now sitting in these sorts of coffee shops, relying on the fact that there will be people using insecure Wi-Fi so that they can then go in and they can start hacking your computers. So you might want to make sure that all your staff who do go out and about mitigate these risks, and obviously, try and reduce the risk of confidential information getting out there. In addition to these sorts of day-to-day things, we've got things going on a worldwide basis. So what we have here, and thank you to Norse for this, and if you're interested, you can go onto their website, and what this is a slide of a still where if you actually go onto their site, you can see this all happening in real life. This is, at the time I did the printout, showing you where there are hacks originating from and where they're going to. And so you can see in the circles, you've got hacks going on within the US, you've got hacks going on around China and the UK, but it's like a lot of missiles flying around from one side of the world to the other. But they are all live hacks as you are looking at them. And you can see down at the bottom there, the actual origins of some of those hacks. So you've got the United States, you've got China, the Netherlands, then you've got the attack targets, and then if you're interested in it, you can then start to see the type of hack as well. But of course, with China and with Russia, you know, they are very much into the hacking at the moment, and they want to disrupt business as much as they possibly can. In each of these hacks, there's going to be the risk of data being attacked. And I was working with a firm not so long ago where they were actually hacked. And it turned out, after all the various investigations, that it was the Chinese government that was involved in this. Now, were they after Mr. and Mrs. Jones's conveyancing file? Excuse me, no, they weren't. What they're obviously trying to do is disrupt the UK's business operations. Now, that particular firm would have had some significant difficulties had it not had hard copy files, because it had actually got into some of the backups as well, which was obviously a problem for them. When we got involved, we obviously had to report that to the SRA because there was it was a material breach. We then had to update the SRA in the future because obviously there were new things that we found from the IT company when it was looking at things, and we had to look at the mitigation going forward. So making sure that your backup is a lot further away from your live data as well. But quite clearly, there's lots of things going on out there that we need to be aware of, and obviously legislation needs to cope with all of that. So in terms of the EU General Data Protection Regulation, you know, we're talking about EU there, and it hasn't replaced the Data Protection Act 1998. What it has done is it's actually enhanced that particular act. We obviously now have the Data Protection Act 2018, and there's lots of things in there that will be new to people, but the majority of things are still as they were. So as long as you were complying with the 1998 Act, then there won't be a problem. It applies to all processing of personal data of EU individuals, and it gives obviously individuals a lot more control over what they're doing. Now, I can hear some of you saying, but what about Brexit? Well, Brexit will have no impact whatsoever on GDPR. The whole purpose of the Data Protection Bill was to implement GDPR into UK legislation, and that's exactly what it's done. So whatever happens with Brexit, it is here to stay, and we need to make sure that we comply with it. Certainly I am aware of some organisations who thought that GDPR would disappear off the radar as and when we left the European Union, and therefore they are way behind on their data protection journey. So please don't think that this is going anywhere anytime soon. So who does GDPR impact? Now, again, I could get into lots of different technicalities and different scenarios as to whether you are a controller or a processor or a joint controller, a sub-processor, all those things. I'm not going to get into that. Suffice to say that if you're a law firm, you will be taking your client's data. Therefore, you will be using it for the purposes that your client has given it to you for, and therefore you will be controlling that data. So as I say, you and the business will be a controller. Now, of course, what you will then want to do potentially through those transactions is then outsource that data to other people who may need to be providing information and services to your clients, and they therefore will be processors. Now, as I say, there will be different scenarios depending on who you are and what you're doing and everything else. But I think, you know, if you can just bear in mind that you are the controller of your client's data, and others that you have working with you, like experts, people like that, they will be processors. Now, you'll note I haven't talked about barristers there. I'm going to come on to them later on, because certainly the Bar Council has put its position, and that position was not one that I think the majority of people thought it would be. So we'll come back to that later on. So what does GDPR bring? It brings new principles. We'll go through those in a moment. There's some new definitions as well. I suspect the majority of you will not need a compulsory data protection officer, but we'll go through that as well in a little bit more detail. And we'll go through some of the increased data subject rights. So as I said before, you already had a lot of those rights under the 1998 Act, but you've now got a few more as well. And if nothing else, what GDPR has done is it's actually woken people up to the fact that they had these rights. And certainly I am seeing now a lot of people exercising those rights. And I'm going to give you some examples of those later on, because people are actually taking action now that they've got those rights, and GDPR is now in force. We also have privacy by design, which is where you have to make sure that privacy is built into everything that you do in terms of your processes. If you're going to change your computer systems, you need to be making sure that privacy is built into that. So when you're talking to your suppliers, make sure that they're aware of the requirements under GDPR as well. And we're going to talk about breach notifications, and I'll give you a bit more detail on that. And I've really gone through a little bit of risk management already, because I've talked to you about what are we doing in public places. Well, in effect, we've identified the risk, and then we manage that risk by keeping things out of sight of other people, putting filters on screens, not talking, and all those things. That is pretty much basic risk management. It's identifying the risk, and then it is managing how we actually try and make sure that risk doesn't materialize. So here we are. We're starting off with principles and what they mean. But I think before we really start going into these, just need to remember one really basic thing, and that is just ask yourself the question, is what I'm going to be doing fair? So is what I'm going to be doing with somebody's data fair? It is fair to be processing somebody's data if they come to you as a client and they want you to perhaps do a residential conveyance. So you'll be sitting down with them, you'll be talking to them, you'll be getting details from them, perhaps for money laundering purposes and other things like that. That is fair. What wouldn't be fair is for you then to be passing those details onto a friend of yours who perhaps runs a furniture shop round the corner, who might be able to then tap the client for some furniture sales or things like that. So again, you would be saying to yourself, is passing this person's details to somebody else who is totally unrelated, totally unknown to the client, fair? Well, no, it isn't. So you just don't go there. So if you can actually sort of ask that question right at the very beginning, then you should be fine then looking at all the other things. So looking at lawfulness, fairness, transparency, make sure that it is lawful. Make sure that we are being as open and transparent with clients as we possibly can be. Again, I go back to really the rule of thumb that I have, and that is, do with others data as you would wish done to your own. I'm sure if you were clients or customers, you would want to have all the various details in order for you to make decisions. And certainly if that's what you want, then you should be giving it to other people as well. Don't just see clients as just a fee. They are more than that, and certainly you would want to be treated as more than that if you were in their place as well. The purpose limitation. So we have to look at, well, why are we holding this data? Why are we getting it? What are we doing with it? And we shouldn't be using it for things that we haven't got it for fairly. Now, some people will therefore be saying, well, I can't market my other services and all that sort of thing. Well, yes, you can, because there's legitimate interests and there's other things which I'll go through in a moment. But the fact is, if you are, for example, getting involved in a conveyancing transaction where somebody's just sold a house, they've got £50,000 at their disposal, but during conversations with the client, you found out they didn't have a will, but you forgot to actually address it with them while they were in front of you, there is no reason why the firm can't then contact them through the wills and probate department to market services there, because it's in the legitimate interests of the firm to do so. And as long as you've covered it in your privacy policy, then there shouldn't be a problem with that. But as I said before, it doesn't mean that you can then start using it for all sorts of unassociated things. And obviously we're not allowed to do cold calling anyway, but you certainly wouldn't be wanting to do it for that. In terms of data minimization, again, we need to try and keep data to a minimum where we possibly can. And one of the biggest issues that I find when I'm going around firms is looking in people's offices, and what do we normally see in fee earners' offices, and certainly it hits a lot of raw nerves when I'm talking to people about this face to face, and that is they'll have all these files in the corner, and they're closed files on their way to archive. They've still got residual balances on them, and they're just stuffed in a corner waiting for somebody to actually deal with it. I have come across fee earners who have then turned around to me and said, well, what do you want me to do, earn fees or do the administration? And my view is you do both, because that's exactly what you should be doing. And so, fee earners need to recognize that we need to get those files out, get them to where they should be, and get them safe. Because if you have piles of files in your office and they all start falling over each other, you could end up with other people's data falling into other people's files. And the moment that client then says, well, actually, I want my file back, or I want it transferred to a new lawyer, then of course you've got a real issue, because you've then sent other people's data to somebody who isn't entitled to have it, and therefore you have a breach of the Data Protection Act. So if you can have a clear desk policy where it's appropriate, where it's proportionate, that would be great. Getting all these files out. This is one of the good business reasons about GDPR. It gives you an opportunity to have a very good spring clean and really have a look at what your staff and what your firm is doing, and maybe changing things for the better. In terms of accuracy, again, I've had firms who have been saying to me, does it mean we have to contact every single client where we've got a file in archive to see whether they've changed their details? No, it doesn't, because at the time of the file going into archive, hopefully it will have been up to date and it would have been accurate. Now, as long as it was, then there is no need to bring the file out. Again, we're talking about proportionality, we're talking about common sense here. Now, of course, if you then did get the file out, because let's say, for example, the file was relating to a house purchase and now you're dealing with the house sale, then you may want to get the file out. And if you do, to put other documents onto the new file, then you'd update the file at that time and then you'd put it back into archive. Again, it's accurate as at that time. So we don't need to be going to those sorts of extremes. And storage limitation, a lot of firms will be keeping their files for long periods of time to take account of you know, the legal requirements, or whether it's because you might have a claim against you or a complaint or whatever. Well, as long as you have your storage periods and your archiving and destruction periods in your policies and such like, then that should be fine. Make sure that your privacy notice, your privacy policy refers to all of this. One of the things I have found when I go around to firms is that they will say, we keep your documents in conjunction with our, in compliance with our Data Protection Act and policy, but actually they then don't provide them with a copy of the policy. So the clients actually don't have access to the document that they really do need. So make sure that you actually link them together. And obviously we need to make sure that documents retain their integrity and confidentiality as well. So in terms of definitions, I've spoken about data controllers, i.e. you as the business, and you know, they determine the purpose, conditions, and means of the processing. Again, these are the sorts of definitions that we need to look at when we do need to get into more technical areas where we have to work out whether somebody who's working with us is a controller or a processor. And we have just discussed their processor, and of course the data subject is your client, but also you as individuals. But we've also got biometric data. So, you know, let's not just focus on, well, personal data is only about name, address, telephone number, things like that. It is physical, physiological, or behavioral characteristics of an individual, which allows their unique identification. So it may be somebody who has a disability, whatever it might be. You know, they might only have one arm, they might have diabetes, whatever. So that is their personal data as well. So please do look beyond just the sort of the normal things that people tend to regard as personal data. Talked earlier on about the data protection officer. I suspect the majority, as I said before, you don't need a data protection officer because you don't, or you're not a public authority. Your core activities don't require you to have one either. And obviously, you probably won't be dealing with large scale. And I think, you know, large scale, well, what is large scale? Who knows? I suppose you really just got to make a judgment on it. But certainly, I would think the likes of Yahoo, the likes of Google, Facebook, well, obviously, they're going to fit into that. Large law firms will also fit into that. Certainly, the very large law firms will fit into that one. But I suspect the normal high street firms, the smaller firms, won't. But what we then have is, should people appoint a DPO voluntarily? Because yes, we want to make sure that we're showing the regulators the right things, the right approaches that are being taken. But a lot of people have appointed a data protection officer when they didn't need to, without fully appreciating the obligations that then come with that. Now, are there liabilities for the individual? Well, no, there won't be. But what firms need to understand is that there could be a lot of cost involved in getting that DPO trained to the level that is required. And you can see in this slide, and you will get copies of these slides in due course, you can see that actually, they've got to be, it's got to be commensurate with the sensitivity, complexity, and amount of data and organization processes. So, the expertise there, have expertise in national and European data protection laws. So the amount of cost that could go into this could be quite substantial if you are going to meet, and you would need to meet these requirements if you are going to go down that mandatory road. You've also got to understand that the role is statutorily independent and protected, so there will be contractual issues as well. One of the things you do need to bear in mind, of course, with GDPR, there's a lot of call on people who are data protection officers, qualified, and all those things. So bear in mind that you could have a flight risk potentially, depending on who you appoint as a DPO, if that's what you wanted to do, because if they've got those sorts of additional skills, then of course other people are going to be after them. So there is a risk that you may not need to worry about, or if you didn't actually appoint a mandatory data protection officer. So do have a think about that before you make decisions, or if you've already made that decision, you might want to rethink that one. In terms of the subject rights, well, there's lots of different rights, but what you've got to make sure is that you know the Data Protection Act enough to be able to turn around and say to clients and data subjects, no, because at some point you may be in a position where you have to and you can say no, but you need to understand when those particular times are. So for example, we have a right to erasure. So this is the right to be forgotten, as it's been called by lots of people. And so what you wouldn't want is a situation, and I suspect the majority of people listening to this, I think, are conveyancing people. But even if you're not, there will be other reasons why you've got people's ID and you're doing money laundering checks and things like that. But of course, what we'll be doing is we will be engaging with clients in transactions where we need to do AML checks. And we will need to get ID, we'll need to get utility bills, source of funds information, and source of wealth information, and all those sorts of things. Now, of course, under the data protection regulations, we have an obligation, legal obligation, to retain that data for 5 years. If we then start saying, okay, well, you've asked for the right to be forgotten and erasure, we're now going to shred all your files and we're going to ditch everything off our computers, but without recognizing the issues with doing that, if you if you are under the money laundering regulations, you could go from thinking you've just complied with the Data Protection Act, and actually, excuse me, you've just walked straight into a criminal offence under the money laundering regulations. So what you'd be saying is, well, yes, thank you, Brian. You've asked me to forget you and erase all that data, but actually, I have other reasons that override your rights, where I have to keep certain data. Now, it doesn't mean you then keep everything. It only means you keep everything that is related to that particular lawful purpose, i.e. money laundering. So you wouldn't necessarily be keeping all the other things that you don't need for that money laundering purpose. The other thing, of course, is you may have legal obligations to keep them for other reasons as well. It may be that potential claims and complaints and those sorts of things. But you do need to be able to recognize when you need to say no to clients. It's really, really important, that one. Right to access, so this is subject access rights. I'm going to go into some of those in a moment, because obviously there's certainly been a lot of those being made since people recognized or remembered that they had all these particular rights. But this is pretty much where somebody can come in or send you an email or actually just phone you. And I think it is important to recognize that as well, that you cannot force people to write to you. You cannot force people to text you or whatever it might be. If they contact you by phone, then you make details of it. You take the details and you then perhaps write a letter to them or an email to confirm, is this exactly what you asked for? But you can't force them at the beginning to actually put this into writing. So be very, very careful with that. And again, you need to look at what you're going to be providing to them as well. Some people have actually thought, or some clients tend to think, that they can use this as a means of getting around liens and not paying their fees and things like that. I don't think they can, because of they would be expecting to be able to walk away with all of their file. Well, they're not going to get that. by putting in a subject access request. So, you know, if you do get clients trying to think that they can usurp that process by doing a subject access request, well, you need to have a think about that one and basically say, well, sorry, but that's not the way this one works. We obviously want to make sure that information is correct. And so we have a duty there if we get a request to update information to then do that. So, you know, make sure that you are ready to update data where necessary. And we also need to be in a position where we can allow clients to port their data across to somebody else. So, for example, you know, they may be with you, but they then want to, for whatever reason, move across to the firm across the road. And therefore, you need to be in a position to be able to give them their data so that they can take it away with them. So what have some firms encountered? Well, certainly I did a poll, and I did some LinkedIn blogs as well. I do a lot of those. So if you're interested in getting involved in those, please do. But I thought I was doing pretty well, having a client phoning us up and saying that they'd had a subject access request from one of their clients at 8:30 as soon as they got through the door. But I was then beaten because somebody let me know on LinkedIn that actually one of their clients had actually contacted them at 12:10, the moment, you know, 10 minutes after GDPR had come in. So quite clearly, people are beginning to exercise their rights. We've also had clients phoning us up and saying, you know, somebody's put in a subject access request rather than going through the litigation process or all of the litigation disclosure process. Again, you need to think about those very, very carefully and the context in which it's being asked for, because it may be that actually you need to go back to the subject and say to them, look, there are proper ways to do this in the context of what you're dealing with here, and therefore you need to ask for disclosure through the litigation process. There's also been clients who have had their clients phoning them up saying, you know, I want to be forgotten. So the erasure, and again, they've been asking, you know, well, what do we do? How do we track everything down? What do we do in terms of marketing to them and all those sorts of things? So again, lots of people exercising their rights. And there's also been demands to know where a firm has got a person's data from. So again, this is important that you actually do your information asset register so you know where your data's come from, where it's going to, what you're doing with it, so that if you do get these questions, you can obviously deal with that. And one that I dealt with yesterday, in fact, subject access request made to the processor, not the controller. So again, you know, one of the things that you need to think about is, well, who should this access request be made to? As we found out, they'd actually made a subject access request to the controller as well. So what we then did was advise the firm to actually refer the subject to the controller, and that the controller would then contact us as the processor, and they would then go through the relevant bits and pieces from there. So just be careful of some of these requests and just make sure that you are clued up on what you should be doing with them. Or certainly, you know, if you're working with us, you can give us a call and we can help you from there. Now, in terms of breach notifications, again, one of the rumors that was floating around was that every single email that you sent to the wrong place had to be reported to the Information Commissioner's office. That isn't the case. You only have to report where there is a risk to people's rights and freedoms. So just putting this in a very simple context, if you were to send an email to the wrong place and it only had their name and address on it, I would suspect that that does not infringe on people's rights and freedoms. Individuals may think differently, but certainly we have to draw the line somewhere. But if you actually had a medical report in that email that was going to the wrong place, then in my view, I think you have got issues in terms of rights and freedoms, and therefore you would need to be reporting that both to the ICO and the client themselves without undue delay, and certainly within 72 hours. Now, that doesn't mean that you have to give them chapter and verse of the whole breach. If you can notify them, and then subject to further investigations, you would write to them and you would then say to them, we've got some further information on this one for you. And that's exactly what we did with the firm that I was talking about earlier on, who was hacked by the Chinese government. Obviously, as you can imagine, there was a lot of work that needed to go in there with the IT company. And it was only at that point that we were then able to make a further report on behalf of the firm to the SRA. Now, what we need to remember, of course, for those of you who are regulated by the SRA, and I'm sure other people who are within the regulated sector will have their own rules on this, so bear this in mind. But if we look at the bottom of this slide, we have the reporting threshold. So we now have an email that's gone to the wrong place. So it's not impacting on somebody's rights and freedoms. Now, we ordinarily, purely looking at the Information Commissioner's requirements, it would not be reportable because it's not above that particular threshold. However, what we need to remember is, and as I say, it's not just the SRA, it may be other regulators as well, actually it potentially is a non-material breach, so we need to be talking to our compliance officer for legal practice, and also any breach of confidentiality, putting aside data protection, we're now talking about confidentiality, is a breach that is reportable immediately to the client, even if it is just saying we've sent your name and address to the local car repair shop by mistake, but this is what we've done to remedy the situation. We've got the email back and everything else. And then, of course, if we do reach that threshold, that's when we have to start reporting to the ICO. We've already reported to the client under the SRA regime, so we wouldn't necessarily need to be reporting again to the client for the ICO's purposes. But of course, we then need to be considering a material breach report to the SRA as well. So you can see there that we mustn't lose sight of the fact that yes, we're looking at things at the moment on a data protection basis, but actually we have a regulatory compliance issue to deal with as well. Ongoing GDPR obligations, a lot of people tended to think that once we hit the 25th of May, that everything was going to go away and we could just sort of put the manuals in the cupboard and forget all about them. That is not the case. We have to be monitoring this on an ongoing basis, reviewing policies, reviewing systems, and looking at what we're actually doing. Do we need to be giving staff training? We've got staff coming in and out of the business, so we need to be reviewing those sorts of things. Just while I'm talking about staff going in and out of businesses, you need to be making sure, and I've had a number of cases of this, you need to be making sure that when you have somebody who is looking to leave your business, you potentially put them on a watch list, because they could be trying to take data away from you. It's normally done through USB sticks. It can be done through sending large attachments to private emails. Your IT team should be put on notice to be watching that, because the theft of client data, the theft of your data, it is a serious offence. And I have had dealings with people who have had those sorts of issues. But when I have done that, I've also then found that actually it's not just data going out of the firm when people are leaving, it's also data that's coming into the firm from people who are joining the firm, who have taken data from their previous firms. It's theft, and therefore it needs to be dealt with accordingly. It shouldn't be seen as, oh, they're bringing new clients with them. Well, they're only new clients if the clients have consented and the firms have consented. It's the same with will banks. We see people selling will banks around and with a view to making a nice little killing on it. The fact is, you cannot transfer will banks to anybody unless the clients have consented individually. So it's their data. So you need to get their consent before you do anything like that. So please make sure you do the right things before you start thinking that they're a commodity and you can just pass things around. Again, it comes back to, is it fair to do with this person's data what I'm about to do? Now, just putting some of this into a law firm context for you, those of you who are working in family, you're going to be dealing with very sensitive information, so you need to be looking at things there. The same applies to personal injury and clinical negligence, because you've got medical information floating around. Those of you dealing with property, on the normal basis, you won't have sensitive information. However, you do need to be thinking about, have we got an internal referral from our family department or our wills and trusts department where actually there could be sensitive information on that file. So don't just take it for granted, well, I'm only dealing with SDLT forms or things like that. There could be sensitive information in that file. The same with employment, because you're dealing with discrimination claims, so you'll be dealing with sensitive data that includes medical, disability, race, religion, those sorts of things. And of course, you need to remember that although businesses may not be covered by this Data Protection Act, individuals involved? Maybe. So, you know, don't take it for granted that just because you're dealing with a business, none of this applies to you. What I also tend to talk to firms about is the client journey, and this helps with the designing and implementing of the information asset register. So if you think about the journey that one of your potential client or one of your clients has had going through working with you, then this will certainly help. It will also give you a context in terms of the type of information that you're collecting, what you're doing with it. So if we just follow the slide there, we start with inquiry and quote, and yes, some of these will overlap because, you know, you may not have an initial meeting. It may be all done over the telephone or whatever, the same with taking of instructions. But certainly if you think about the information that you're collecting during those phases, then you are collecting a lot of personal data. You could be dealing with a lot of sensitive data if there's accidents involved or it's family, divorce, all those sorts of things. You're going to be collecting data, I suspect, when you're sending client care letters out. You're going to be asking for various information, and particularly you're going to be asking for client due diligence information, so your IDs, your source of funds and things like that. So lots and lots of information coming in and also continuing to come in during your ongoing communication with your clients. Now, of course, then you start instructing counsel and experts, and you start having your information or your client's information going out. So this is where we were talking about, you've taken it in as a controller, you're now passing it out as a controller, but to somebody who is going to be a processor. Now I've got counsel there, I'm going to come back to counsel in a moment, so just exclude those from the sort of the processor bit at the moment, and it'll become clear in a moment as to why that is. We've also got outsourcing work, so are we passing work out to South Africa or India or places like that? We need to be thinking about that and the risks that go with it. It might be appropriate, if you're looking to do that, that a data protection impact assessment is done to make sure that you've covered off all the security and other issues that go with putting data into environments that perhaps aren't as safe as they are here. We've also got liaising with third parties. Now, in this particular context, the example that I would use is in relation to somebody who is gifting a deposit or something like that. Now, does it mean that you've then got to be giving them a full-blown privacy notice? No, it doesn't. Because what you can do is when you're writing to them to say, you know, I believe that you are gifting this amount to son, daughter, whoever it might be, that we need to have an understanding of who you are, and we also need to have an understanding of your source of funds for money laundering purposes, which is a legal obligation, and therefore we will be retaining this, using that data for that purpose only, and we will be retaining it for a minimum of 5 years, but probably for the period that we're retaining your son, daughter's file. That's pretty much all you need to put in there, because you're telling them exactly what they need to know about what's happening with their data. And of course, we then have file closures, archiving, destruction, and we need to make sure that when we come to destroy a hard copy file, that we're not just destroying hard copies, we're also destroying the soft copies on computers, because certainly that's something that I found with a lot of firms, that they're not destroying the soft copy stuff that they've got. And so they may have destroyed the hard copy at 6 years, but they've left everything else on there for the last 4 because the client left them 10 years ago. So make sure you're doing looking at everything there. Now, in terms of consent, this again is something that's been subject to myths. We have written consent, but written explicit consent is only one of 6 lawful purposes in relation to the processing of data. And I think the 3 out of those 6 that would be most suitable for the types of engagements that you've got will be necessary for the performance of a contract, i.e. somebody coming to you and saying, will you sell my house? So you'll have client instructions, so you will have that contract, even if it's verbal at the very beginning, you have those instructions. Necessary for the compliance with a legal obligation, again, you need to collect certain information for the money laundering regulations, so you don't need to ask the client for their consent to do that. You have a legal obligation to do it anyway. And then, of course, we have legitimate interests, and this is where I was talking about the cross-selling of services within your business. But of course, what we've got to do is make sure things are justified. I suspect there will be a lot of marketing companies out there who may not be able to justify using legitimate interests. And therefore, as and when regulators do start knocking on doors, they may fail in justifying their reason for using legitimate interests. But I suspect most law firms will be able to use those three. And of course, the one at the bottom there is the one that you would normally be wanting to use where you have sensitive data. So you would have to have one or all of the three that I've just talked about, plus this one, if you're dealing with sensitive data. Now, there are others, and you might want to have a look at that, but I think this is the most appropriate one that you'll find for dealing with client matters. So what do we need to give to clients? Well, we need to give them the privacy notice. Now, again, I did a poll very recently, and the vast majority of people are now using separate privacy notices. And then in their terms and conditions, they are just putting under the GDPR or the data protection clause or heading, they are just putting in there, please see attached privacy notice. I think that it is good practice to certainly have all of it sitting out separately from T's and C's. Certainly if you are using explicit consent, it has to be separate anyway. But I think it is good practice in any event to have it away from the small print. Make sure people can read it right up front and they understand what you're doing with their data. Again, you need to accept that you need to talk to people differently depending on who they are. Because if you're dealing with vulnerable people, you're dealing with children, then you do need to actually talk to them about the privacy notice in a different way to perhaps somebody who has all their faculties and they're a very technical user of law firm services and such like. So make sure you're doing the right things there. Some of the typical issues I come across, emails going to the wrong place, spoke about that. That seems to happen on a daily basis. Wrong documents attached to emails, talked about that one. Documents left in a public place. So tell your fee earners when they're going to court or going to visit clients, if they want to stop off at Sainsbury's or Tesco's or anywhere else to get a sandwich on the way back, not to leave the file in the bottom of the basket. I have had one or two firms that have reported that to me. Other firms have reported their fee earners going to the car park and they'll put the file on top of the ticket booth, get their ticket, and then they walk off and leave the file on top of the ticket booth. There are people out there who want their 15 minutes of fame and they don't think they'll get it by bringing the file to you. What they'll do is they'll either put pictures of it on LinkedIn or Facebook or whatever, they'll put it around the world that way, or they'll take it to the local paper. And the first thing you know about it is when you get a reporter on your doorstep saying, why was this left in this particular place? So please make sure people look after the data they're being given. Be careful what people are doing on trains as well, leaving bags and things lying around. People are looking to take them, so make sure that you're aware of where they are at all times, particularly when trains are coming to a stop. And documents sent to the wrong place because people haven't actually updated the practice management system. The biggest issue I come across is where people have just sold somebody's house and they've just sent all the other documents back to the house that they've just sold. So conveyancers, please take note of that one. In terms of barristers and chambers, this is the one where people were thinking that actually the barristers are processors, but they're not. They are controllers in their own right. Now, what I would do, I'm not going to get into all the technicalities of that, but what I would certainly do is have a look at the new standard contract terms between barristers and lawyers, and you'll get a pretty good insight into that as well. If you want further information on that one, and you want to perhaps have a look at the letter that the Bar Council issued in relation to this, just let me know and we can obviously provide that to you. Just in terms of staff, because we shouldn't forget them either, we need to be looking after their records as well. What we don't want is their records sort of sitting out on open areas with people having public access to them and things like that. You need to protect those in the same way that you do clients' data as well. So make sure they're secure, make sure they're restricted. And of course, your normal processing will be legitimate because you have a contract of employment, you have legal and regulatory obligations to do things, so under the Equalities Act and other things like that. And of course, you'll have legitimate interests as well. I have heard some firms where actually some employees have been coming to them to say that they want the right to be forgotten in relation to disciplinary issues that they've had 3 months ago. Well, quite clearly, they need to keep those. So I would certainly be making your staff aware that, they can't have the right to be forgotten in circumstances like that. there are good reasons for GDPR, and obviously I raised one earlier on in terms of giving yourselves an opportunity to do a spring clean. But I've also come across people where they've actually saved £15,000 a year on file archiving costs because they've been able to reassess how long they keep files for, and they've got ongoing savings there. So again, there are good business reasons for this. It should not be seen as a tick box exercise. The regulators, I can see through anybody who's doing this just because it's a tick box. Just to give you an example, I have had some firms where they will put in their manuals, we lock everything away during the day, and we only get files out during the day when we need them. And then when you walk into their offices, there's files everywhere. So, don't just put something in there because you think it's going to tick a box, because at some point you may be asked to actually justify what you're saying. If you can't, for proportionality reasons or whatever, if you can't actually have everything locked away, then put in there, we will endeavour wherever possible to do this and this and this. It doesn't put you then as a hostage to fortune. But as I say, don't just see this as a box ticking exercise. That's me finished. So what I'm now going to do is hand you back to Rose, and we can then go from there. But I hope you've found the session useful, and I'm sure there'll be some questions that we can then look at from there. So back to you, Rose.